we had such battles over social economic rights in the Constitution. And that wasn't the British way. Parliament looked after health, education, all those different things. And rights meant the right to speak, to vote, to assemble, maybe to own property. And social and economic rights had nothing to do with the courts. The courts could simply see that the laws passed by Parliament were adopted in an appropriate way. Now, I'm in the ANC, I'm in exile, I'm a lawyer. I'm helping to prepare our members for having a constitution one day. And the basic plan being promoted by Oliver Tambo, based on a paper that Paulo Jordan had produced in 1985 in exile, was to have majority rule and a Bill of Rights. The Bill of Rights was fundamental. It was the answer to group rights. Group rights would have meant we had a parliament with Mandela president on Monday and de Klerk on Tuesday and Buthelezi on Wednesday, and they'd have to agree on everything. They're representing their different groups. It would have been a total catastrophe, a disaster. The Constitution would have stood in the way of change and would have been the enemy of the people. So I was at first very reluctant about a Bill of Rights. Too much power to the judges. I belong to the critical legal studies groups. Your rights are gained fighting in the public sphere and in Parliament, and the judges must stand back and not be involved with rights. But I could see the importance of a Bill of Rights, individual rights for everybody in the country, as the counter to group rights. And then, once you're going to have a Bill of Rights playing such an important role, why should rights simply be the rights of the rich and the powerful, the civil and political rights, not to change the status quo? We want an emancipatory vision of a Bill of Rights. And for most of our members to say the right to education is not as fundamental as the right to vote, and you're saying we're too stupid to have the vote, and you deny us education. To say the right to health isn't as important as the right to speak your mind, and our children are dying of measles and preventable diseases. Come on. The right to food, to water, to social security, to say these are not fundamental rights, couldn't just understand that. They couldn't separate the two. So I started writing in the 1980s about the emancipatory vision of a Bill of Rights, and I introduced the notion of the 3 generations of human rights. It had been proclaimed by a Czech person working in the United Nations. He wanted to put green rights on the map. He couldn't slot them in. So he said human rights have gone through a very powerful evolution, starting with the civil and political rights of the late 18th century in France, United States, the right to vote, to destroy the power of the kings and the others. That had been followed by social and economic rights. Bismarck, this Prussian autocrat, wanted to get the German working class on his side. In Prussia, introduced, later on the Russian Revolution put them on the map, later on the social democratic countries of Northern Europe, the Labour Party in England, social and economic rights, the 2nd generation. And the 3rd generation of human rights, this Czech writer said, would be the rights to development, to peace, to the environment. Carter Asmal called them the blue rights, civil and political rights, the red rights, social and economic, the green rights at different phases. And so I'm now trying to encourage our members, the people participating in the struggle for democracy in South Africa, to see a Bill of Rights as an expansive emancipatory document. And so I've become an ardent enthusiast, like many converts. I'm very ardent in favor of social and economic rights. Negotiations start. They're not in the interim constitution. Interim constitution was very advanced in administrative law, fundamental rights, in sexual orientation, it's there. But they said, no, this is too controversial, can't go into the interim constitution. The final constitution now, the elected parliament deciding on the constitution. Powerful battle from the great majority wanting social and economic rights there. We had some precedent in Ireland in the 1930s. Social and economic rights are in the constitution, but they expressly declared not to be enforceable by the courts. India, such an important precedent for us. Constituent Assembly, I think it was 46, 47, that period. They include social and economic rights, but simply as directives of public policy, not as legally enforceable rights. The judges, years down the line, actually used the social and economic rights to provide texture to the fundamental rights. So the right to life was seen not simply as the right to existence, not to be killed, but the right to a dignified life, bearing in mind. So judges can do a hell of a lot with text if the will is there. But we felt, no, in South Africa we don't want this indirect kind of a thing. We want social and economic rights to be fundamental rights. And at the international level, there'd been a huge division at the United Nations, with the Western countries by and large being very strong on civil and political rights, but very reluctant to include social and economic rights. So it was the Third World, and the Socialist Bloc, as it was called at the time, had a separate convention on social and economic rights, the West not signing up to it. Some of these debates followed in our own parliament, but massive support for social and economic rights being fully justiciable rights. That means you can actually get them enforced by the courts. And that battle was won. But how to enforce them? You can't say from day one. From day one, everybody has a right to free speech. From day one, everybody is an adult, has the right to vote. Civil political rights, you don't ration them. You can limit them in certain ways that are permissible, you don't ration them. But social and economic rights, you can't say everyone has a right to a house. And you don't have the funds, and you have to have a queue, criteria, progressive realization. So we took from the United Nations International Convention on Economic, Social and Cultural Rights, we took the notion of the state being under an obligation to take measures to progressively realize the rights within available resources. What our parliament did, the Constitutional Assembly did, was to add the word take reasonable measures, taken from the International Convention, and that was put into the text of our Constitution. And instead of that taking reasonable measures being declared as a general principle to be applied to each of the rights, it's spelt out in the right to health, take reasonable measures. The right to education, basic education, is there, it's unqualified. Tertiary education, secondary tertiary education, reasonable measures. The right to water, to food, to social security, reasonable measures have to be taken. So that's now the format of the legislation. And the very first case we had Mr. Subramani. It was a tragic case. He was dying of renal failure. He'd collapsed, been to hospital, received dialysis. In the emergency crisis situation, they said, sorry, Mr. Subramani, but we have to give preference to, we can only handle 30% of people who present themselves to us. These machines are expensive to operate. We have a long queue, and it's taking money away from other medical programs. And we give preference to people who would benefit from renal transplants. And you're a very bad candidate. You've got ischemic heart disease, you've got diabetes. Too bad. He goes to the private sector. They training the family's resources. He's not getting better. They say, we can't support it anymore. He comes back to hospital. He's dying. The hospital turns him away. He comes to court. The pressure on the judges is enormous. Find the money from somewhere. But can we interfere with the decision taken by the ethics committee at the hospital to give priority to people who would benefit from renal transplants? And in the end, we decided we can't put him at the head of the queue, that the criteria they used were rational, were fair, and it's not for us as judges to step into their shoes and say who should get priority. That's something that should be left to the ethics committee in the hospitals. Our law clerks were furious with us. You could have found the money from somewhere. He died 2 days before our judgment came out. It was a heart-rending case. And Arthur Chaskelson, writing for everybody in the court, said, the rights in the Constitution have a hollow ring if there aren't the resources available for fulfilling them. And I remember saying to counsel, appearing for Mr. Subramani, Mr. Soames, I forget his name, knowing the weight he felt on his shoulders, the weight I used to feel when practicing in the apartheid courts, and my client might get the death sentence. If I mess up, my client will die. And I could feel he had that heavy weight on his shoulders. I said, Mr. So-and-so, if compassion and resources were co-equal, this case would be very easy to resolve. But unfortunately, resources don't extend to meet the needs of compassion. And Mr. Subramani died before our judgment came out. The next big case was the Grootboom case. We knew it was a big case. I remember the year because when I would describe the case in America, Grootboom is the big tree. It was the time of Bush Jr., the little Bush, the year 2000, the famous elections. And we knew this case was big, that she had been with 1,000 other people then the problem in Cape Town was flooding, not drought. And they couldn't bear the idea of another waterlogged winter, so they'd dismantled their shacks, moved to a nearby hillside with their little belongings with them, put up their shacks to discover that area had been set aside for low-cost housing, and they were low down on the queue. So they were evicted very roughly and ended up on a sports field. Not these beautiful sports fields you see in URC competitions all over the world. A bit of dusty, dry land with a small stand of concrete, and the winter rains are approaching. And I remember imagining Mrs. Grootboom lying out in the open with her children and her sister and their children, and saying, why? Why? We've done nothing wrong. Why are we sleeping out in the open, like maybe 1 billion people in the world? And all I want is a roof over my head and a place for my children to grow up. And I'm sitting up on the bench and I'm saying, how? We are judges. We don't know about finance, about construction, about housing, about priorities. And yet, if she's sleeping out in the open because of evictions, what does the right to housing, progressive realization, mean in our Constitution? We got wonderful support from council, council from the state, council for Mrs. Grootboom, Legal Resources Centre. It was Jeff Butlander, not even the main council, who possibly had the biggest impact in terms of the ideas that were presented to us. We had terrific discussions around the table afterwards. I don't think there's another court in the world where we had that has workshops like we had. We had a brand new court, brand new constitution, a completely different vision of law and the role of law in our country, not law to keep people apart, law to bring people together, to recognize the dignity of everybody, how to make it work in practice in a meaningful way. And we pulled in two different directions. The one is to say, gosh, you know, if they don't get some protection, then the Bill of Rights is meaningless. You couldn't get a more dramatic situation, sleeping out in the open fields like that with nothing. They couldn't go back to the sites that they'd left because other people were now occupying those sites. But we're judges. This is not our speciality. This is something for government, for Parliament to deal with. So that tension was built into the decision in Grootboom. And we looked very closely at the way the Bill of Rights was framed. Everybody has the right of access to adequate housing. The state shall take reasonable legislative and other measures progressively to realize the right within available resources. And it was the word reasonable that became our hook. I think it was Archimedes said, give me a lever and I can lift the world. You need a lever as judges, an organizing principle that can lead to a result that is compatible with the Constitution. And the lever was the word reasonable. The word reasonable is used a lot in law. Reasonable force in self-defense. Drivers must drive reasonably and not be negligent. And reasonableness is very contextual. Depends on the circumstances. It's balancing out. And we decided that's going to be our lever in the enforcement of social and economic rights. It's not an individual right to come to court and say, I want a house, I want a place at the university, I'm in need. It's the duty on the state to take reasonable measures progressively to realize the resource, the rights. And reasonableness would give a wide latitude to government. We don't have that expertise. They have the expertise. They have the hearings. They can get the evidence. They can balance out all the competing principles. They're answerable to the electorate. But it must be within the realm of reasonableness. And what was unreasonable in the case of Mrs. Grootboom was not that she was low down on the waiting list. It was that she had nothing. Extreme desperation, lying out in the open there as a result of state action. And we said the Housing Act had a progressive realization. By then, something like, I think a few 100,000 houses had been provided free to people. The state, in that sense, was taking reasonable steps. We won't interfere with that. But it's unreasonable to have nothing in the Housing Act dealing with circumstances of total desperation. Victims of fire, of flood, of eviction, they've got nothing at all. So the very least you must have is temporary shelter. And we said that was unreasonable not to have temporary shelter. And she got a temporary shelter. She won what she was asking for, not a house, but temporary shelter awaiting the house. Sadly, she died before, I think it was just months before her family actually got the house. But she did get the temporary shelter. And that progressive realization then, depending on budgetary availability, giving the government, the elected government, a very wide range of possible responses was crucial. They could realize that right by giving people land, saying, build your own houses, or by financing social housing, a whole different range of mechanisms, by getting huge subsidies to private people to put up the buildings, make them available, by rental accommodation. That's up to government to decide. But it's got to be within the parameters of reasonableness. And not having crisis, emergency, shelter available was not reasonable. And that became foundational to our approach to the enforcement of social economic rights, the reasonableness of the state action. People in the human rights community have challenged that. They want a minimum floor of basic rights, which is measurable, and you can go to court if you're below that minimum floor. The court resisted that on the basis that difficult to establish, floods of challenges in the courts to get hospital beds, to get access to housing and so on, and it would become unmanageable for various reasons. But that's being debated now, and people are asking for a possible relook at the approach of the court in that regard. The other important area that the court introduced was in terms of, we called it meaningful engagement. And that's a very South African thing, meaningful engagement. It's not for the court simply to declare the law. Thou shalt provide the houses, thou shalt provide alternative accommodation. It's getting the parties together and to say, these are the constitutional dimensions of the case. You want to evict people from buildings they occupy in the center of Johannesburg or Durban or wherever it might be, because the buildings are run down, they're dangerous to health, and you want development of the city. But you can't just chuck out the poor people. They must have somewhere else to go, and don't tell them you can go 20, 30 kilometers out. The little work that they've got is in the area, maybe picking up scraps and selling for a couple of R100 a month. That's all that they've got. Find mechanisms. The city, recalibrate your thinking. Find somewhere where they can go if you want to have the development and the beautification of the beautiful cities. Talk and come back to us and tell us what you've got achieved. So that's not an available resources mechanism. It's a bringing the poor into the process of finding a viable solution. It's so important. They have a voice. They're not just anonymous people without histories, without names, without stories, without different needs. Give them an opportunity to represent the particular needs, the solutions that would be sufficient for each one of them. Get the city council people also to come up with their particular needs, report back to the court. And that's softened the impact of the redevelopment that's based simply on the ideas of expelling the poor, making them fend for themselves in a way that's inhuman, that the Constitution doesn't contemplate. That's not an available resources aspect. It's giving voice to those most directly affected, a chance to engage and to find solutions that would be viable. So the question is sometimes thrown at me, what about the money that's not spent? The municipalities that are sending the money back because of incompetence or whatever it might be. I'm going to duck that one. My colleagues might have to face up to it one day, but it'd certainly be a strong challenge. Clearly, part of the remedy is the political process. Hold them to account and get people in office. Part of the remedy is to change the structures of local government, to have permanent people in place dealing with management, so that you don't have local portfolios for housing, for welfare, for whatever it might be, that change every time there's an election or that there's a change in terms of who the mayor is. So I think myself, a combination of responses, political response, institutional structural response, but maybe there's scope for judicial response. I'm very happy to leave that one to my colleagues.